may be seated. I apologize for the delay. It's not typically how we handle matters here, so my apologies. We had a number of things to address with the attorneys before we could proceed.
Your Honor, there are two individuals involved in this one.
There are 3 individuals in the court Zoom waiting room.
Judge, one is the guardian, the other one is from Justice for Kids, and the other is a civil attorney.
Thank you. Good afternoon. I have allowed some individuals into the conference to participate and view the proceedings. Please make sure your camera is on, that you are stationary, and that you are on mute. Please make sure your camera is on, that you are stationary, and that you are on mute. And then we can proceed once everyone has handled that. You can have one other individual who I have sent a prompt to start her video. The name on the screen is Warner.
Yes.
I'm not sure if she's having technical problems.
Possibly. I think there might be some internet issues.
I'll give you a minute to make sure she's compliant with court procedure. I know we have Ms. Dennis here for victim advocacy, and I'm wondering if you've had an opportunity to communicate with the individual in the Zoom.
I'm texting her, but she hasn't responded back.
She's left the conference, so I did not remove her. If you'd like me to give you a minute so that she has an opportunity to be present, I can do that.
Yes, Your Honor, please.
Sure. We'll take 5 minutes. And we did give you, sir, a media form. Okay, thanks. We're going to go on the record on State of Ohio versus Jason Santos. This is case number 24124036A. I have here Attorney Emily Hall on behalf of the State of Ohio. I have Attorney Chris Parker here present in person with Mr. Santos, who's also in person in custody from the Summit County Jail. I do have prosecuting witness representatives present by video, and I know Attorney Hall, you have victim advocacy here as well. I understand the parties have reached a resolution and that Mr. Santos wants to engage in a plea. So I'm going to first hear from the State of Ohio on that matter.
Yes, Your Honor, it is the state's understanding the defendant is prepared to plead guilty to the indictment in this case. The state, in exchange, will not be seeking a sentence of life without parole, which he is eligible for under count 1 of his indictment. And I just ask that you inquire of the defendant.
Thank you. Attorney Parker, I'll hear from you on behalf of Mr. Santos.
Your Honor, that is accurate. That is the substance of the discussions I've had with the state. I've had ample time to discuss this matter with Mr. Santos, and it is his intent to withdraw his former not guilty plea to the indictment and enter pleas of guilty to the counts against him in the indictment. I
afternoon, Mr. Santos.
Good afternoon.
My understanding is that you are here today to accept responsibility for and plead guilty to a number of counts for which you have been indicted in this case and for which we're set for a jury trial on Tuesday of next week. Is that your understanding, sir?
Yes, ma'am.
I want to go over with you first what it means to plead guilty to any offense, okay?
Yes, ma'am.
First, it means you're giving up your right to plead not guilty, which you've done up until now, and to go forward and have the trial that we are scheduled to have. And you could have had your trial, Mr. Santos, in front of me or in front of a jury of 12 people. All 12 people would have had to agree that you're guilty before they could have found you guilty. And it would have been the prosecutor's burden to prove beyond a reasonable doubt each and every element of every offense that you face. That's their burden of proof. You understand that, sir?
Yes, ma'am.
Mr. Santos, you don't have a burden of proof, but you have rights available to you as a defendant. You have the right to cross-examine any witness that they would have called to testify against you. Do you understand that?
Yes, ma'am.
You have the right, sir, to subpoena witnesses and compel them to appear and testify on your behalf. Do you understand that as well?
Yes, ma'am.
And Mr. Santos, you have the right to testify yourself in court under oath. Do you understand that too?
Yes, ma'am.
Now, you don't have to exercise any of those rights. You have the right not to exercise them. And no one can force you to exercise those rights, and no one can hold it against you if you choose not to exercise those rights, including testify. So you can choose not to testify in a trial against you, and no one can hold it against you. And I want to make sure that you understand that.
Yes, ma'am.
Do you have questions about the fact that when you plead guilty, you give up these rights?
No, ma'am.
So by pleading guilty, you're making a complete admission of your guilt to the charges that you're facing in this indictment. And then the court will find you guilty because you've made that admission. And these offenses will be recorded as a conviction on your record for each offense, and you will be sentenced. Do you understand that, sir?
Yes, ma'am.
I want to make sure you also understand that there are consequences that are associated when you're found guilty of these offenses. And it's my job to make sure you understand them, okay?
Yes, ma'am.
At count one, it's the count of rape. It's a felony of the first degree. You face a minimum period in prison of a life term with your first opportunity for parole after 25 years. Do you understand that?
Yes, ma'am.
And I wanted to make sure Attorney Hall and Attorney Parker that you have reviewed that and agree that that is the minimum sentence that Mr. Santos faces for count one, rape, a felony of the first degree.
Yes, sir.
Yes, sir.
Mr. Santos, you also, though, face the possibility that the court could impose upon you life without the possibility of parole. And that is a penalty that you face for this offense. I recognize that the state has agreed not to request that of the court. You understand that?
Yes, ma'am.
At count 2, 3, 4, 5, 6, those are 5 separate counts of felonious assault. Those are for specific incidents regarding this prosecuting witness's victim, okay? And so I want to make sure you understand that each of those counts carries a separate penalty. Do you understand that?
Yes, ma'am.
Each of these is a felony of the second degree, Mr. Santos. And the important thing for you to know is that felonies of the second degree of this nature, they don't carry what we call a definite term. They carry an indefinite sentence. And an indefinite sentence consists of a minimum term and a maximum term. The minimum term for a felony 2 is anywhere from 2 to 8 years. Do you understand that?
Yes, ma'am.
The maximum term then, sir, is determined by calculating the minimum term and mathematically adding 50%. And so that's important for you to understand, because if your minimum term on a felony 2 is 2 years, which is the lowest minimum term you could receive, then your maximum term on that offense is 3, because it's 2 plus 50%. Do you understand that?
Yes, ma'am.
Do you have questions about that?
No, ma'am.
Mr. Santos, if you received an 8-year minimum term on that felony of the second degree, then the important thing to understand is you could get a 12-year maximum term. Do you understand that?
Yes, ma'am.
And that's available for any one of these felony 2 counts. And the court is permitted to run consecutive or concurrent the sentences that are associated with these counts, which is important for you to know. Consecutive means stacked on top of each other. You understand that?
Yes, ma'am.
And it's hard to understand that when you have a term of life in prison, but what it means is that if I ran any of these terms consecutive to your term of life in prison, then your first opportunity for parole would change depending on what the sentence was, and it could be increased. Do you understand that?
Yes, ma'am.
Do you have questions about those penalties?
No, ma'am.
Your last two counts at 7 and 8 are endangering children, and they've actually been indicted at different levels of offense, and so it's important for me to make sure you understand that. Count 7 was a child endangering felony of the second degree, which carries the same penalties as those felonious assaults, right? A minimum term of anywhere from 2 to 8 years, a maximum term of anywhere from 3 to 12, based on the mathematical calculation. You understand that?
Yes, ma'am.
The felony of the third degree is at count 8, and that is called endangering children, but it's a different level felony. That offense carries a definite sentence, anywhere from 9 to 36 months. And again, counts 7 and 8 can be run concurrent, which means at the same time, or consecutive, which means stacked on top of the sentence for any other offense. And I want to make sure you understand that too.
Yes, ma'am.
Do you have questions about that?
No, ma'am.
So, I've explained to you these minimum and maximum terms available for these felony 2 offenses. I've explained to you the penalty associated with a felony of the first degree rape. I've explained to you the definite term you could receive on a felony 3. You are not permitted to earn good time credit on a sex offense. And that's important for you to know, because on the felonious assault offenses, technically you would be eligible, but because you're serving a life term with your first opportunity for parole after 25 years at a minimum, it's important for you to understand that earned good time credit is not available on that sentence. Do you understand that?
Yes, ma'am.
Typically, on an offense where you could earn good time credit, you could earn anywhere from 5 to 15% towards your minimum sentence for good behavior, and the court could deny that. They'd have a hearing on it if you did. It's important for you to know that typically on these indefinite sentences where I told you you can have a minimum and maximum term, typically regardless whether you got good time credit, you would be presumed eligible for release when you finished your minimum term, unless the prison decided to keep you there for bad behavior. And if that happened, they would give you a new release date, and they would reevaluate your behavior, and they could do that over and over again until the maximum term. If your only sentence was for an offense like that, then no matter what your behavior was, you would have to be released at the end of your maximum term. Obviously, you wouldn't want to wait till you're a maximum. But in this case, you understand, sir, that the heftiest penalty is the term of life with the first opportunity for parole after 25 years. You understand that?
Yes, ma'am.
And that can be run on top of other sentences that you receive. You understand that too?
Yes, ma'am.
It's important for you to know that the offense that you're facing is mandatory prison time. And that's on that rape offense. And so what that means is that you will not be eligible for community control, judicial release, other prison programming opportunities during that sentence. It means you will serve every day of that sentence until your first opportunity for parole. You understand that?
Yes, ma'am.
Now, it's important for you to know that post-release control is a term of supervision given to people after they're released from prison by the adult parole authority. And it means they're supervised by the adult parole authority, and that they are in charge of a person's behavior after prison. And they actually have the authority to send that person back to prison if they don't follow the rules. They can send you back 9 months every time you violate. They can send you back for up to half of your sentence or stated minimum term for the total of all your violations. And in fact, when somebody's out on PRC, if they pick up a new offense, a new felony, while you're being supervised, then your new judge can sentence you on your new case and add time consecutively. Remember, I told you that means stack it on top of the sentence because you picked it up while you're on PRC. And I'm advising you about it because your felony 2 offenses carry mandatory post-release control of anywhere from 18 months to 3 years. And your felony 3 offense carries a mandatory post-release control term of anywhere from 1 to 3 years. But I want to make sure you understand, post-release control does not apply to the rape offense. Do you understand that?
Yes, ma'am.
That is an offense for which if you are eligible and you are granted parole at any time during your lifetime, you would be on parole. You understand that?
Yes, ma'am.
And so because of that, I think that is what's going to apply upon any release from prison, because that's going to be the longest sentence that you serve. Do you understand that, Mr. Santos?
Yes, ma'am.
Do you have questions about that?
No, ma'am.
As part of your sentence, I can also impose upon you a fine. A felony 1 carries a $20,000 fine. A felony 2 carries a $15,000 fine. A felony 3 carries a $10,000 fine. I can impose court costs. Of course, I have to find that you have the present or future ability to pay that, and I don't believe that we're going to be able to find that if you're serving a life sentence in prison, but it's my job to tell you what the penalties are that are associated with the offense. Do you understand that?
Yes, ma'am.
Mr. Santos, one big consequence that you face is that once you are convicted of, and because you pled guilty to this sexually oriented offense, this child victim offense, you will be determined to be a Tier 3 sex offender subject to community notification. And so what does that mean? It means that you would be required to register in person with the sheriff of the county in which you establish a residence within 3 days of coming into that county, or if you were temporarily there for more than 3 days, okay? And I want to make sure you know registration for a sex offender centers around residency, employment, and education. So you would also be required to register in person with the sheriff of the county in which you established a place of education immediately on coming into that county. And the important thing to know there is if you established a place of education in another state, but you maintained a residence or temporary dwelling here, you would be required to register in person with the sheriff or the other appropriate official in the other state immediately upon coming into that state. Do you understand that?
Yes, ma'am.
I understand that these registration requirements seem far off to you because you are going to be imposed a term of life in prison with your first opportunity for parole at the earliest 25 years, and depending on if I stack any other sentence, longer than that. But it is important for you to know that you are still a Tier 3 sex offender upon conviction here, and that these registration requirements apply upon release. And so I've explained to you residency registration and education registration, but it's also important for you to know that you would have to register in person with the sheriff of the county in which you establish a place of employment. And you have to do that if you've been employed for more than 3 days, or for an aggregate, a total of 14 days in a calendar year. And just like with education, Mr. Santos, if you establish a place of employment in one state, but you maintain a residence or temporary dwelling here, then you have to register in person with the sheriff or the official in that other state. Again, if you've been employed for more than 3 days, or for a total of 14 days in a calendar year. So that's important for you to understand. Also, employment includes volunteer services. Other registration requirements, Mr. Santos, that I'm obligated to tell you about are things like you have to provide the sheriff temporary lodging information anywhere you're going to be at for any length of stay. If your absence is going to be 7 days or more, you have to give them that address and how long you're planning to be there. And then after you initially register, it's my job to make sure you know that you have to periodically verify those things. Your residence, your place of employment, your place of education, in person at the county sheriff's office, no earlier than 10 days before that verification date. Do you understand that?
Yes, ma'am.
Mr. Santos, if you change any of those things, your residence address, your place of employment, your place of education, then you have to give written notice of the change to the sheriff with whom you most recently registered, and the sheriff of the county in which you intend to either reside or establish a place of education or work. And you have to do it 20 days before any change. You have to do it no later than 3 days after you change the employment. And it's important for people to understand that you are required to register even if you don't have a fixed address. Sometimes people are couch surfing or they don't have a stable residence. You still have to provide a detailed description of the place or places you intend to stay. And then no later than the end of the first business day, once you get a fixed address, you have to register that. There are other requirements that you need to know in accordance with federal law. You have to report any international travel to your registering authority. You have to do it no less than 21 days before you travel, or you can be criminally prosecuted. And you have to provide written notice within 3 days of any change in your vehicle information, in your email address, any internet identifier, any telephone number that was registered to or used by you. You have to give that to the sheriff with whom you most recently registered. And these Tier 3 registration requirements, Mr. Santos, are for your lifetime. You have in-person verification every 90 days. My understanding is that your expected residence address was Summit County, However, I know that you sent the court a letter recently that you wanted to be in New York. I don't have the authority to send you to a New York prison, but I want to make sure you remember what I told you about registration, and you will get this in writing as well. You are required to register in person in another state if you have any residence, education, place of employment. You understand that, Mr. Santos?
Yes, ma'am.
If you fail to register, if you fail to verify your residence at that specified time, or you fail to provide a notice of a change in those things, the required information, you can be criminally prosecuted. And it's my job to make sure you understand those things, as well as understanding something that people sometimes don't realize is that you cannot reside within 1,000 feet of a school, a daycare, or a preschool. So now that I've explained these things to you, and I'm sure Attorney Parker went over them with you as well, I'm going to hand the form to Attorney Parker so that he can give it to you and you can sign those things that we've discussed. Do you have questions about those registration requirements, Mr. Santos?
No, ma'am.
Thank you. Mr. Santos, I've now explained to you all the penalties that are associated with the offenses for which you're pleading guilty, and I want to ask if you have any questions about those penalties.
No, ma'am.
Do you have any questions about the rights that you are giving up by pleading guilty?
No, ma'am.
And you understand again, sir, that this means that you have made a complete admission of your guilt and you will be found guilty and sentenced.
Yes, ma'am.
Mr. Santos, are you a United States citizen?
Yes, ma'am.
Are you under the influence today of any drugs or alcohol or medication?
No, ma'am.
Has anybody promised you anything or threatened you to get you today to plead guilty to these offenses?
No, ma'am.
Mr. Santos, do you suffer from any physical or mental disabilities?
I got ADHD, bipolar disorder, post-traumatic stress disorder, depression, anxiety.
Okay. I appreciate the list of those concerns for which you are struggling. I want to understand from you if you're taking any medication for those disabilities.
No, I'm not.
Okay. Have you discussed in detail with your attorney the consequences that you face and the rights that you waive?
Yes, ma'am.
Have I told you today anything different than you understood before you walked in here today?
No, ma'am.
And again, you don't have any questions about that.
No, ma'am.
And the reason I'm asking that is because sometimes when we struggle from mental health concerns, it's my job to make sure that despite that struggle and despite those diagnoses, that you have a clear understanding of what you're doing today. Does that make sense?
Yes, ma'am.
And you do, sir?
Yes, ma'am.
What's your understanding about when you'll be sentenced, Mr. Santos?
I should be sentencing on Tuesday.
Yes, so that's my understanding from the parties that we've agreed, that you will not be sentenced today, you'll remain in custody, you'll be brought over on Tuesday for sentencing. Attorney Parker, that's your understanding as well?
It is, Your Honor.
Mr. Santos, have you had enough time to consult with Attorney Parker before proceeding today?
Yes, ma'am.
And has he gone over with you the things we talked about, the plea form, the charges, the consequences, the rights you're waiving?
Yes, ma'am.
Has he answered the questions that you have for him, sir?
Yes, ma'am.
I want to make sure you understand that any appeal in a criminal case would normally be filed within 30 days after your sentence. That's the rule. If you couldn't afford an attorney, the court could appoint one to represent you. But certainly accepting responsibility and pleading guilty to these offenses limits those rights on appeal. Do you understand that, sir?
Yes, ma'am.
Mr. Santos, do you have any questions, again, about the rights you're waiving or the consequences that you're facing?
No, ma'am.
Before I proceed to ask Mr. Santos for his plea, I want to make sure from the state of Ohio and from Attorney Parker, if there's anything that you feel that the court needed to address in this colloquy. Attorney Hall.
Nothing more to say, thank you.
Thank you. Attorney Parker.
No, Your Honor.
Mr. Santos, understanding all the rights you're waiving and understanding all the consequences that you're facing,
Yes,
I'm
ma'am.
going to ask you for each offense. How do you wish to plead to count 1, rape, a felony in the first degree?
Guilty.
How do you wish to plead to count 2, felonious assault, a felony in the second degree?
Guilty.
How do you wish to plead to count 3, felonious assault, a felony in the second degree?
Guilty.
How do you wish to plead to count 4, felonious assault, a felony of the second degree?
Guilty.
How do you wish to plead to count 5, felonious assault, a felony of the second degree?
Guilty.
How do you wish to plead to count 6, felonious assault, a felony of the second degree?
Guilty.
How do you wish to plead to count 7, endangering children, a felony of the second degree?
Guilty.
And finally, Mr. Santos, how do you wish to plead to count 8, endangering children, a felony of the third degree?
Guilty.
Mr. Santos, I do accept that you've entered your plea knowingly, intelligently, and voluntarily, and I do find you guilty as to all 8 counts charged in the indictment. The court will proceed to sentencing on Tuesday. The court is not required to obtain a PSI for a prison term. The court has no intention of doing that. And so we will proceed. And I just want to look at the calendar and see what time we have to do that. It would be helpful if we could do that at 11 a.m. Does the state intend to have anyone speak on behalf of the state?
Okay, we will either have a letter or one speaker to the court by Monday.
Okay, and how about you, Attorney Parker? Okay, just for scheduling purposes. So we will proceed at 11 a.m. on Tuesday, April 21, with sentencing. Anything further from the state?
No, you can say this one.
Anything further from you, Attorney Parker?
No, Your
Mr. Santos, anything else you want to address with the court?
No, no.
Okay, then this matter is adjourned. Thank you.
Thank you.